I'm Walter Isaacson of the Aspen Institute, and we're here with our third lesson on the Reconstruction Amendments. And I'm with Jeffrey Rosen, the CEO of the National Constitution Center in Philadelphia. So now we get to the 15th Amendment. First, let's put it on the timeline. When did it happen?
Passed by Congress February 26, 1869, and ratified February 3, 1870.
And we call these the Reconstruction Amendments, but let's get the whole timeline straight. Reconstruction basically begins with the end of the Civil War in April 1865 and pretty much ends with the end of Ulysses S. Grant's presidency at the beginning of 1877 when Rutherford Hayes takes over. Is that about right?
That's exactly right. The Compromise of 1876, which gives Hayes the presidency, and the deal is that the Southern Democrats agreed to support Hayes in exchange for the end of Reconstruction.
So Reconstruction was a big, broad thing that helped change the way the laws were applied in the South, but at the core were these three amendments, right?
They are the mark that was left in the Constitution, constitutionalizing the vision of the Reconstruction Republicans.
So let's get to the 15th. What does it say?
It says, "The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude."
In other words, freed slaves could vote.
In theory.
So first of all, why was it necessary? Wasn't that an obvious thing?
It was necessary because the 14th Amendment, which we talked about last time, only protected civil rights, not political rights. This was a distinction that was important to the Reconstruction Republicans. They thought that although a citizen of Maryland could go to Virginia and make contracts, the same Maryland citizen couldn't go to Virginia and vote in Virginia elections or on Virginia juries. And therefore, all Section 2 of the 14th Amendment also seems to anticipate that Southern states might deny African Americans the right to vote, but reduce their apportionment in Congress accordingly. That's why, even though the 14th Amendment guarantees equality of civil rights, it took the 15th Amendment to guarantee equality of the political right of voting.
Now, you said in theory it allowed freed slaves to vote. Why just in theory?
Because soon after the 15th Amendment was passed, Southern states did their darndest to disenfranchise African Americans by ruses and other stratagems. They passed grandfather clauses that prohibited people from voting if they hadn't been registered before the Civil War. They passed poll taxes that made it impossible for African Americans to afford to cast a vote. And the Supreme Court, in a series of decisions, some of them written by liberal heroes like Justice Oliver Wendell Holmes, upheld these appalling stratagems. So in practice, African Americans could not meaningfully vote in many Southern states until after the civil rights movement of the 1960s. It really took the Voting Rights Act of 1965 meaningfully to give African Americans the right to vote that they were promised more than a century earlier.
Under what ground did Oliver Wendell Holmes and others sort of overturn what is the clear intent of this amendment?
Well, it was an amazing decision. It was called Giles, the Giles decision, and Holmes basically said only formal forms of disenfranchisements are prohibited by the amendments. Ruses that have the effect of disenfranchisement aren't covered. And then he said, basically, if the Southerners are perpetrating a fraud on African American citizens, the court can't be a party to the fraud by presuming to strike it down. It was a really striking and appalling
And when
decision.
was that decision?
That was soon after, it was in the 1870s, soon after the 15th
So
Amendment was
pretty
passed.
much these or at least the 15th Amendment, is undermined or at least made irrelevant within 10 years of passage.
This was the time of Jim Crow beginning to rise up. It was the time that the court upheld a railroad segregation in Plessy versus Ferguson. It's such a tragic story. It was also a time when the Supreme Court struck down the Civil Rights Act of 1875, which had been passed to guarantee equality in accommodations and access to public places. So you have this shining promise of Reconstruction embodied in these amendments, but very quickly Southern states act to deny the promise with their laws, and the Supreme Court just repeatedly and relentlessly sides with the South and against the intention of the framers of the Reconstruction.
So throughout the 1870s, and it's not just the South now, it's the Supreme Court as well, throughout the 1870s, you said Plessy versus Ferguson, that basically says what?
That's by 1890, and that says that railroad segregation, where Southern states are compelling railroad carriages to separate blacks and whites, is perfectly consistent with the 14th Amendment. That there was a stirring dissent by Justice John Marshall Harlan, saying that the Constitution is colorblind and neither knows nor tolerates classes among citizens. Thurgood Marshall read Harlan's dissent before arguing Brown versus Board of Education, and it wasn't until 1954 that the Supreme Court essentially overturns Plessy and recognizes that segregation is a violation of the 14th Amendment.
So from the 1870s to the 1890s, we pretty much have the undermining of at least the 15th Amendment and somewhat the Equal Protection Clause, and it's almost 100 years. How does it happen 100 years later? We have the Voting Rights Act. What else?
I suppose it really began after World War II, when African Americans served with whites honorably in the war, and Major League Baseball was integrated, and public opinion about segregation began to change. When the Roosevelt and Truman administrations argued against segregation, and by the time the court struck down school segregation in 1854, repudiating the doctrine of separate but equal, public opinion was nationally against segregation. 54% of the country opposed segregation in 1954.
And explain what the phrase separate but equal, how does that come about?
Well, it came about, I suppose, from Plessy versus Ferguson, which recognized that you couldn't have completely unequal railroad carriages or facilities, but said it was fine to separate blacks and whites, because if anyone assumed that there was any intention to degrade African Americans, that was just their construction. You know, as long as the railroad carriages were basically the same, then there was no inequality. Brown versus Board of Education repudiated that unconvincing ruse and recognized that both the purpose and effect of segregation was to stigmatize and degrade African Americans as inferior and less worthy than whites.
And so what we have are these three Reconstruction amendments passed between 1865 and 1870, and they really come into full force exactly a century later with the 1965 Voting Rights Act and the other civil rights acts of the 1960s. Is that about right?
That's exactly right, and that reminds us that any notion we have that our rights come mostly from the Supreme Court is not consistent with history, because although we fought a civil war and passed these three heroic constitutional amendments, it wasn't until the people of the United States rose up in the civil rights movement to actually make these rights a reality.
Thank you, Jeffrey Rosen.
Thank you.